comment. I think in terms of the Havelock North water inquiry per se, in terms of the HBRC staff members involved in it, in particular, Ian's going to bear a heavy. He's borne a heavy load, and he's going to bear a pretty heavy load in the inquiry process as well. Or probably the leading role, really, Ian. So I think on that basis, you're going to know the subject from all angles by the end of it. Hopefully, you get a Christmas out of it. Yes, I just wanted to make that comment about one staff member of ours who really is going to be under the pump. Okay.
Thanks for that good news, Andrew.
Thanks, mate. It's all right. Build you up.
So look, councillors, the report's pretty self-explanatory, but I just wanted to go through and just pick up on some key points and add some emphasis to it. In effect, the background describes to you kind of the process by which this thing began and our initial view of what was happening and the work that we then commenced to understand what was going on. And it notes that these science investigations are still underway, and so we still have tracer-dyed testing on the go in the field at the moment, and that won't conclude until next week sometime. What I would make the clear point on, though, is that early in the process, as the paper said, there was a view relayed to us that there was an issue with the groundwater resource generally, so we spent quite a bit of effort looking into that to establish whether that was the case, and it isn't, and still is not. So we have confidence in the aquifer, and the aquifer is showing no signs of broad contamination as a result of this incident. So I think it's an important point for me to make and for the public to hear, because in time this inquiry is going to be as much about what happened as restoring confidence in resources and processes as they exist now or as they'll look like in the future. Just noting that the inquiry was gazetted in September. It then has, if you like, launched formally just recently, last month, and has set a timetable by which the inquiry will run, of which there are two parts. So the inquiry put to the participating parties the view that it would separate the inquiry process into two phases, one of which is how did the contamination occur, and the other being what are the systemic issues, either in law or in policy, that need to be considered or addressed as a result of that. And so there was agreement that should and would happen. And the intent being that the phase one, if you like, how did it happen, is potentially going to conclude prior to Christmas, and the board may well write its findings on phase one early and ahead of phase two. That's certainly the initial view or thinking that they provided to us. In terms of our formal RMA investigation, that's close to conclusion. So the file is being reviewed by council and staff at the moment, and then will come to Andrew shortly for some decision making. So that's all I can tell you about that at this point. Just flicking back into the inquiry, important, I think, just reflecting the discussion that the chair of the panel provided us on the day, is that he's clear that it's not a court, so it's not going to be run as a court. He doesn't want to see extensive cross-examination of witnesses, for example, and he doesn't want to see a lot of opinion and speculation about the what-ifs. He's very interested in the facts and the evidence, and for that to be presented to him and the panel members to consider and then inquire of, with the view that if they feel they need expertise to inquire of that or provide opinions on it, they'll seek that themselves. So in terms of the phase one exercise, that's always been our clear position anyway. We were simply looking to figure out how did this happen and conduct a bunch of investigations, tests, examinations in the field to try and figure that out. And that's the information that will be fed up to the inquiry process with the exchange of briefs of evidence later this month, leading into the inquiry proper starting on the 28th. In terms of that investigation, there's been a high workload on staff, and in particular the science team, and they've responded really well, and it's been some really good work come out of that, and actually some work that's going to be useful for us for this resource well beyond the initial inquiry process. And I guess finishing off the stage 2 part, which is the public policy and the discussion of law as the paper sets out. That's very much the sort of thing that council will want to have a view on, and the intent is to bring that back, the kind of submission that will go into stage 2 back to council for your input prior to it being handed up to the inquiry process. So I'm happy to take any questions.
Yeah, thank you. And I'd just like to, if we can keep comments till later at this time, because any specific questions on this paper or on this issue to Ian, who has been managing it for us. Paul.
Yeah, I have 2 questions for clarification. Is point number, or paragraph 18 on page 77, the evidence of, what is it you call it, evidence of brief? The statement of evidence, sorry. You're going to give us the brief after it's been submitted. Is there any reason why we can't see that before it's submitted?
Primarily because it's not finished and probably won't be until the 11th hour on the 18th.
Okay.
Because the other point I should have made, actually, it is a good question, is that the inquiry set a very aggressive agenda. It needs to report back by March next year, and we initially thought that day one of the hearing they'd say we're not going to achieve that. Day one of the hearing they said we're going to achieve it. So it's put enormous pressure on everybody. It means that we are literally concluding work as we are writing evidence. So I doubt very much, Councillor, that it will be ready until probably the minute before it's due on the 18th. And it's literally down to the wire. And the other point I'd make just around the briefs is that you'll see in the attachment, the second minute of the inquiry has made it really clear that the briefs will be confidential until they're heard. So albeit we're absolutely happy to share those with you, there will be the need for confidentiality with those.
I'll make a comment, Councillor, too, in addition to that. So the first, we need to set it as quickly as we can, provide you with that information, provide you with a brief in and around, probably post the 18th, obviously, is what Ian's saying. But in particular, I would really I'd just emphasise this point, is that information and that brief flowing to the inquiry, while it's confidential, it also resides in facts, not speculation. So, you know, that's really fundamental, in that they do not want speculation. They don't want any particular agency or institution speculating on things. That's their job. So. But what I think it will do is at least give you a very good insight into the sort of work that the team's done here and what it's shown in a factual sense, okay? And the commitment is to do that as quickly as we can.
And Council, perhaps if it helps also, on page 89 you'll see the table of contents of the investigation report. So it gives you a sense of what's going to be in there. Obviously the detail's still being developed at the moment, but those are the sorts of things that are going to be traversed.
Yeah, no, that's fine. I was more interested in just having a bit of a heads up before it all hit the inquiry, but that's cool. I can understand you logic. Yeah, that's fine. The other question I've got is that you've got a budget in there which was approved of 135,000, which is fine in itself. Do you think that's going to be enough, given that you've engaged Chen Palmer, who have a reputation for charging like wounded bulls?
So this is just in relation to our investigation, not the broad process. And look, I've just had quickly pulled together some figures, and we're still well within budget for those. So I'm pretty confident that we will stay within budget for that investigation phase.
Thanks, Mr. Chair, and thanks, Ian. Thanks for the earlier information, which has helped me understand your dilemmas here. I have a question in regard to, or 2 questions. The first is in regard to paragraph 4 in your paper, and where you're saying that during the early stages of the investigations, there was evidence identified that suggested possible breaches by HDC of resource consent conditions. It's my understanding, though, that those breaches have been long-standing over many years. Or there have been breaches over a period of time. Can you confirm the extent of concern, information, etc. you've had around those the water supply issues there from the council's perspective?
So we haven't had concerns previously around the items that are noted in our investigation, which was effectively bore and wellhead security. They have had breaches in the past of the taken use component of the consent, so they've exceeded their rates and volumes at times. They've had reporting requirements they haven't met, so there's been issues associated with the taken use component of it. The reason that we launched the investigation was primarily that there was the initial view that there was contamination of the aquifer, and then a GNS report that came to us second-hand that indicated age of groundwater coming out of that bore had changed, which gave us an indication that potentially the bore and the bore construction and bore security may have compromised groundwater quality in the aquifer, and so that was the area that we started investigating.
I think my question really is around that, the integrity of the bore structure. Had that ever been an issue of concern to officers?
We had never documented that as being of concern to us, no.
Okay, the second question probably addressed to Mr. Newman, and it relates to the minutes, the minute from the inquiry, and it relates to core participants on page 87 of our papers. And at paragraph 33 it says the core participants are a number of the agencies, including the Hawke's Bay Regional Council. Now, I'm just wanting to be clear, I couldn't find under your delegations whether you had in fact had delegations under the Inquiries Act. Are you aware of what your status is in regard to participation there as the person?
Well, I'm not absolute. I have to admit that this process started prior to my taking up the CO role of the council. So I'm unsure, frankly, of the absolute process that the staff gone through with the council prior to the election. So that's generically my first point. As CEO of the organisation, I am bound, or the role was bound by complying with statute where that statute is enacted, whether it's an analogy would be Laguna, where the institution as represented by the CO is bound to comply. So we are bound to comply with the Act, and we're bound to comply with any instruction we delivered. Having said that, if the council wishes to just reinforce that point in a resolution, that's fine. But irregardless, even you as councillors are bound, really, when it gets down to it. Yep.
Prefer if you were bound rather than me.
Yeah, how tightly am I bound? Law, not by rope.
They can subpoena any party too.
Are there any other questions? Okay, do we have a...
Mr. Chair, I wonder whether I could, in that case, address that issue in terms of providing the appropriate mandate for Mr. Newman to react to the inquiry with a resolution plus other issues that I think are relevant to the stage 2 part of the submissions. And I just wonder whether, Leanne, you could put those my proposals up for people to see. The first of them, while we're waiting for that to take place, is that the Council delegates to the Chief Executive authority to report to the Government inquiry into the Havelock North drinking water, the Council's Stage 1 Statement of Evidence, and act as its designated core participant as defined in Section 17 of the Inquiries Act. The second resolution I'm proposing is the Council requires the Chief Executive to make available to councillors on a confidential basis the Council's Stage 1 Statement of Evidence submission to the inquiry. The Council directs staff to prepare a Stage 2 of the inquiry a draft submission for report back to council, and that submission contained a total of 5 questions in regard to the regional resource management plan. They'll come up on the board, but those 5 questions are derived directly from chapter 4.3 of the plan.
Okay, I think, yeah,
Got
they're
the
good.
gist?
So do we have a second to, should we move this paper first or take those resolutions? I think we'll take those resolutions because they are quite fundamental to this paper.
Or-
Yes, fine. Well, I think they're good resolutions.
Yeah.
I'd ask if the staff have got any concern about any
No, I've
element of
checked.
them.
I've checked. Your second? Councillor Dick's second. So we have a mover and a seconder for those resolutions giving authority. All those in favour? Do you want to speak? You've already spoken.
That was remarkably good cheering.
Yeah, you've already spoken. Do you want to speak again? You can speak again. We can.
I'll now know your tricks, Mr Chair.
Just trying to get to a cup of tea. Okay, so we move those and those authorisations, which is excellent. So if we have no further discussion on this paper, do we have a move for the recommendations that we receive this update? Councillor Dick, a seconder? Do you wish to speak to it? Do you wish to speak? Mover and a seconder. All those in favour of accepting this paper? Aye. It's not moved. Thank you very much. Now we have the minor items. We have a list of them which I didn't take down, so we better kick off.
I did.